Grab everybody in. Still more. All right, there we go. Good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of inherited property, clearing title, deferred property taxes, and other probate concerns. My name is Nia Murray, and we are here today representing the a month of service. I'm still letting people in, by the way, so I was get a little sidetracked here. But I am Nia Murray. I am programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us, we have Ms. Cecile Carlson. Also, on behalf of our presenting partners, we have Ms. Lisa Nelson with the Texas Legal Services Center, along with Ms. Donna Pensick with the Harris Central Appraisal District, and Ms. Shay Pinkowski with the Harris County Tax Assessor Collector's Office. But also included in the partnership, we have Houston Volunteer Lawyers, the Earl Carl Institute, and Lone Star Legal Aid. And together we make up a month of service. And basically, a month of service is the collaboration of all 8 of our organizations. We come together on a monthly basis and offer a variety of different workshops relative to asset protection, asset building, the maintaining of generational wealth, and community empowerment. We started this collaboration quite a few years ago in an effort to reach more people, to create a larger impact, and get as much information out to the communities that we all serve. So we would go into an individual community and stay there for an entire month, offering different workshops in person. And then we would go into a different neighborhood and do the exact same thing, which is how we kind of came up with a month of service, just to kind of give you guys a little bit of background. Um, but of course, due to the pandemic, we did have to switch to the virtual platform. It has allowed us the opportunity to reach even more people in even further across the city, surrounding counties, and even the entire state of Texas, and in some instances, people that are joining in from other states. We do broadcast live on our social media platforms, as well as record the session. So we do send out a copy of this recording to everyone that has registered to attend so that they can go back and review it and share the information. And also we'll share the resources that are mentioned throughout the presentation as well. In addition to that, know that what is presented here today is for educational purposes only. It is not to be considered any legal advice. However, we do encourage you to reach out to any of our presenters or any of our legal service partners if you do find yourselves in need of any particular civil legal assistance or any one-on-one about your personal circumstance or your personal situation. This is your opportunity to ask the experts the questions that it is that you do have. However, we do want you to keep in mind, again, that we are recording and also presenting on a live stream. So we want to try to protect your privacy as best as we possibly can. So we don't want your personal detailed information getting out there for everybody to have access to. So you do have the opportunity to either type your question into the chat, or you can wait until the end of the presentation and unmute yourself and ask the questions directly of the presenter. In addition to that, there were a few questions that were emailed in advance, and the ones that are relative to this particular topic, I will definitely make sure that we address those as well. If you are joining us on our social media, please feel free to type your question into the comment section, and I'll make sure that it gets read or gets addressed at the end of the presentation there as well. So um, earlier this week, we had a presentation about title fraud and deed scams, and there were quite a few questions that came up as it relates to what happens when people pass away, and there's other heirs for the property, and basically we don't want to get into too much detail about what happened at the fraud presentation. However, we do encourage you to go back to the YouTube channel to watch that. There was a lot of great information that was presented there, and wanted to make people aware that that title fraud does happen, especially after those loved ones have passed away, either with or without a will in place. So do keep that in mind. This particular segment is actually kind of like the part two of the wills and estate planning, or wills and illegal advance planning, and why do you need it. So that happens, that's the presentation of what happens of, before, how do you plan? This information that we're presenting here today is kind of what happens on the back end, what happens after the loved one passes away, what is the probate process, and how does that all work? We did decide to include, you may wonder why we included the appraisal district and the tax assessor collector's office here, is because that there were so many things that kind of came up after, um, when your loved one passes away. What happens if they've had deferred property taxes and the heirs need to make a payment arrangement or figure out, what it is that they actually owe in order to make sure that the property doesn't get foreclosed on, or what happens when you've got multiple heirs and then someone is still living in the property and you've got an exemption that's available for those heirs. And our presenters are going to go into all the detail about those particular things for you, but that's how it kind of relates together. And then know that all of the workshops that we do offer, they are correlated in some form or fashion. They've kind of evolved over the last couple of years from one segment into another, when we were only doing the wills and estate planning before. But then we started to get the questions about what happens when someone passes, what happens when your loved one passes away. What does it mean to be an administrator or an executor of somebody's estate? What happens if they don't have a will and things of that nature? And then the whole thing with the deferred property taxes. And then if they don't pay the taxes, what happens when the property goes into tax foreclosure because it wasn't paid in time? So there's a whole foreclosure presentation that we do the fourth Thursday of each month. So we're not going to get into the whole foreclosure thing because I know that those were a few questions that we did ask, that were asked in advance as well. But the mortgage foreclosure presentation is going to be on the 20, sorry, the 26th of this month. So we'll get into a little bit more detail about foreclosure, how to prevent it, what that process is like. So do please feel free to tune in there. In addition to that, we also had a presentation last month about property tax foreclosure and what that process is like and what happens if you do find yourselves having your property foreclosed on because of unpaid property taxes. So that was another presentation that we went into detail about. So, but for this particular segment, we're only going to be talking about inherited property and clearing the title when there are multiple heirs, and then deferred taxes and things of that nature. So do keep that in mind. And I went the long roundabout way to explain all of that, just because we got so many questions that were asked prior to about this particular segment. So I just want to make sure that we actually kind of stay on track and not get too sidetracked or get too far into the weeds about other topics that we do also cover in detail in other presentations. So with that being said, there is quite a bit of information that we're going to be covering here today. Again, please feel free to ask whatever question it is that you like. And we hope that you all received the information that you came to get today. So without further ado, we're going to go ahead and go into our introduction and on into our presentation. So Miss Cecile.
Thank you, Nia, so much. Good afternoon, everybody. My name is Cecile Carlson. I am the Outreach Coordinator here at the Office of Neighborhood Engagement with the Department of Neighborhoods, City of Houston. We are one of the partners in the AMOS collaboration, and I'm very excited for the presentation today. Like Nia said, we get a lot of questions from the community regarding the subject matter of today, and so we are just incredibly thankful to have experts on our will be presenting today that will have information that's accurate, and that they will be able to answer some of y'all's questions. And I'm looking forward to learning as well. So thank you so much.
All right. Ms. Shay and Donna, why don't you have you guys introduce first, and then Miss Lisa, you introduce, and then you can go on into your presentation. So Shay.
Sounds good. Hi, good afternoon, everyone. My name is Shay Pinkowski, and I am the Manager of Customer Service here at the Harris County Tax Assessor Collector's Office. We look forward to being able to answer some questions and helping y'all with any queries that you guys might have, in addition to hopefully clearly explaining how the tax process works. But we look forward to your questions. We look forward to being able to impart some knowledge and hopefully be able to help get you guys on the right track should you have any queries for us. But I'm with the Harris County Tax Office. I'm going to go ahead and pass it over to Miss Donna, and she'll be able to introduce herself for HCAD.
Hi, I'm Donna Pensick with Harris Central Appraisal District, and I am happy to be here. And I welcome all of you. And I will also a couple times put my email address, my direct email address in the chat. So if anyone has particular questions on their personal property, you can always email me and I'd be happy to help.
Thank you very much. Did I call you Pensky? Did I say Donna Pensky when I first introduced you? Or did I say Pensick?
I
Okay.
don't think you did.
Yeah,
Okay. If I did, I apologize because I can't
that's
remember.
okay. It's
All
it's a hard last name. Donna Pensick. Thanks.
Pensick. All right. Ms. Lisa, go right ahead.
Hi, good afternoon, everybody, and thank you for joining us today. My name is Lisa Nelson, and I'm a staff attorney with Texas Legal Service Center. I'm one of the attorneys on the Texas Law Help team. We have a website, texaslawhelp.org, which I will probably bore you with how many times I'll mention it during the presentation, but it has a wealth of information about civil law in Texas, from family law to real estate to probate, pretty much anything you'd need about law that's not criminal. And I'm here to talk about clearing title and other probate concerns. So I appreciate you joining us today.
Okay. Okay.
Okay.
And while she's bringing up her presentation again, just a reminder, feel free to type your questions in the chat that you have that are related to clearing title or other probate concerns or questions about deferred property taxes and exemptions. So Ms. Lisa, go right ahead.
And I will not be looking at the chat during my presentation. I will after I move on to our friends at the tax offices and the appraisal district. And we will also have plenty of time for questions afterwards.
Okay.
So today we're going to have a brief overview about the probate process in general. And then we'll talk about how to clear title to inherited property, or heirship property is what a lot of people call it. And then I always like to end with explaining how to prevent any title problems in the future. On Tuesday, AMOS did an excellent presentation on deed theft and also protecting your title. And if you didn't have the chance to see it, I recommend watching the recording. I learned a lot. And then finally, I'll pass it over to the Harris Central Appraisal District, where they will, and then Harris County Tax Office. So Texas Legal Services Center has been around since 1981. We serve all 254 counties in Texas. The office is located in Austin. I am here. I work remotely in Houston. And we provide legal advice, advocacy, representation, and education to underserved people across the state. We have about more than a dozen programs so that we touch almost every aspect of civil law that impacts low-income Texans. I'll put my email again in the chat as well as our websites. So I like to start out with probate concerns. We're a good follow-up to the classes on the importance of probate and how to do your own estate planning. There are a lot of new vocabulary words that you learn when you start dealing with estate planning and probate. The decedent is another name for a person who died. Testate is someone who passed away without a will. If you pass away without a will, you're known as an intestate person or an intestate estate. Testator is the person who has a will in place at the time of death. Testator is also the name we use for the person who is signing a will. They are signing their last will and testament, so they are a testator. And a will is a legal document which states how the testator's property is to be distributed at death. Estate is your stuff. It's both your real and personal property that you own at the time of death. Probate is the process of winding up a person's affairs, and that's whether or not they had a will. It is considered probate if there was a will. It is considered administration if there was no will, but all of that is handled by the probate courts. When someone passes away, a personal representative is appointed. If there is a will, they're known as an executor. If there's no will, they're known as an administrator, and that's the person who's responsible for wrapping up the person who passed affairs and distributing the assets to the beneficiaries. An heir or beneficiary is the person who inherits either through a will or through law. I always think that I can get rid of this common mistakes slide, and then sure enough, I have a question or someone who insists on something. So these are still valid, I learned just yesterday. Powers of attorney are only valid while a person is living. Once a person has passed, the power of attorney is void. So if you have a power of attorney, it means absolutely nothing. You cannot control the person's remains. You cannot wind up their affairs. The power of attorney is only good to care for them while they are living. A surviving spouse has a life estate and the deceased person's home, even if it's separate property. So in Texas, we are a community property state, which means if you're married, property is assumed to be community, which means owned by both spouses. However, if you inherit something or if you purchase a home before you get married, that is usually considered separate property. Surviving spouses, even if they don't have a right to that house, they have the right to live there for the rest of their lives. They are responsible for paying property taxes and property maintenance. And an executor needs to be over the age of 18, and it is best if they live within the state of Texas. There are situations where that can't be helped, but if you have the option, please choose somebody that lives in Texas. It is always Texas has great opportunities to prepare your own will, and I don't want to stop anyone from getting a will if that's their only option. Here in Harris County with the AMOS partners and through the HBA, we have a lot of opportunities for people who qualify to get free estate plans. I'm always going to recommend that you have an attorney prepare or at least take a look at your will and make sure everything is okay. There's a lot of forums out there on the internet, such as LegalZoom. There's a new one called Wills and Trusts. Those are not written according to the laws in Texas. Those are written to be as generic as possible. So they may not be valid in Texas. The one exception to getting wills off the internet, our website, Texas Law Help, has forms that are approved by the Texas Supreme Court. Those are considered legally valid. I can tell you lots of sad stories where somebody wanted to save some money and they found a form they could get online for $50. And, when they pass away, their kids try to probate those wills and they can't because it doesn't have the proper language as approved by Texas law. Spouses must have separate wills. You can't have one spouse write out a will and both spouses sign it. Texas law allows you to handwrite your wills. These are called holographic wills. During the time of the lockdown, when we were all stuck at home, I highly recommended that everyone have a handwritten will. You can find instructions online at our website. Keep your will in a safe place and let your loved ones, at least your executor and hopefully a backup too, know where you keep your will. I understand the importance of keeping your important papers in a safe place, but if no one can find it, you might as well not have a will, because if they're not able to find the original will, Texas law presumes that the will has been revoked. In other words, if you can't find the original, Texas law presumes that you tore it up. If you die without a legally valid will, the law determines who inherits your property. So it's really important to have your final wishes in place. That being said, if you can't find a will, there are still ways that people can wrap up your affairs. If someone has passed without a will, you can file an application for administration. This is really important to consult with an attorney to determine the best way to proceed in probate. In some ways, it's unfortunate that in Texas, you have to have an attorney to go through the probate process. There are good reasons why. One of the reasons is that there are multiple ways in which you can tie up a person's estate, or wrap up a person's estate and an attorney will know the best, most cost-efficient way to do so. There are extremely limited cases where you can file a small estate affidavit. I go into these in detail in a little bit. Here's more vocabulary. Probate assets are property under the property in the testator's name that pass under a will. That could be your real property, so your home, any other property you might own. It also includes your personal property, your household items, your furniture, etc. There are also non-probate assets in Texas. Non-probate assets do not pass under a will. Non-probate assets pass in accordance with the terms of a contract. For example, life insurance policies, retirement plans, any account with a payable on death beneficiary. I need to add a point. If you have a transfer on death deed for your home, it will also pass according to that transfer on death deed and not according to your will. Here's a great secret. If you learn nothing else today, I urge you to go through your paperwork. If you have payable on death beneficiaries on all of your financial accounts and a transfer on death deed for your home, your family may not need to probate your will. Not only does that save them money, it also saves them a great deal of time. When you just have to do the paperwork to transfer things to payable on death beneficiaries, it's a relatively quick process. If you're here in Harris County, you'd be lucky to finish probating a will in 6 months. There's not enough courts. It's a very big, busy county. Small estate affidavits are the one procedure in Texas where you usually do not need an attorney. I believe some counties do require an attorney. And a small estate affidavit is only appropriate in extremely limited circumstances. It can be used to transfer real property only if you meet the following conditions. Only a surviving spouse or a minor that is under 18 child inherits the home. A surviving adult child cannot inherit a home using a small estate affidavit. A small estate affidavit has to be signed by every single heir, not just the surviving spouse. Every single heir has to sign along with it, along with 2 disinterested witnesses. Those are 2 people who knew the decedent well and knew their family history. You cannot have a small estate affidavit if they had left a will. Most importantly, the value of the estate has to be greater than the debts. And this does not include the homestead. So someone owns a home, they pass away, they own $35,000 in assets, but they have $40,000 in credit card debt. They are not going to be able to use a small estate affidavit. Probate procedures, if there's a will or if everybody agrees, are pretty simple. The attorney begins by filing an application to probate or an application for administration. After 10 days, the attorney can schedule a hearing. This does not mean that you get to go to court 10 days after the application is filed. Like I said, Harris County, it could be 6 months or more. But after 10 days, they do have the ability to get on that calendar, the judge's calendar. Once the judge grants the application to probate or the application for administration, the personal representative receives letters. Those are letters testamentary or letters of administration. Then the personal representative gathers all of the assets and opens a bank account for the estate. It's a little more complicated. You have to get a tax ID from the IRS and take that with your letters testamentary or letters of administration and the death certificate, and the bank opens up an account for the estate. That account is to move all of the funds that the person had before they passed away, as well as any funds that the representative receives on behalf of the estate.
After you apply for a tax ID number for the estate.
Correct. So once you get those letters testamentary, hopefully your attorney will do this for you. You get a tax ID for the estate. Then you take your letters testamentary, your tax ID, and you go into a bank and you will open up an estate account. Do not assume that the personal representative is responsible for the debts of the estate. The debts get paid out of what the deceased person had. They do not get paid by anybody else. And do not assume that any bill that shows up has to be paid. The attorney sends notices to creditors, and there are very strict requirements that the creditors have to meet in order to have a legally acceptable debt. And finally, the attorney and the personal representative will prepare and file an inventory. You have to file with the court an inventory that states everything that was owned as of the date of death. Now we'll go into the details for how to clear title for inherited homes. One of the things that I bring up all the time, and I think people should know this, and then I got this question yesterday, you have to probate a will. You have to go through a probate process to clear title to heirship property. Just because it's been in the family for however many generations, you may not necessarily have clear title. And there's a lot of reasons why it's important to have clear title, as you will learn. Clear title means that no one else has an interest in your property. I'm sorry, has a financial interest in your property. It also means that there's no question of ownership, and that the ownership history of your property can be easily traced. Someone could go to the deed records and they could see how the property got to the person living there now, and it's very clear how it happened. When property is not legally transferred or deeded to the new owner, the title is called cloudy. This happens sometimes when somebody dies without a will, or people don't understand that you need to probate a will. I have had situations where an ancestor several generations ago bought this house, and someone in the family has always lived there. It's their family home. Because no one went through the process of clearing title, it's a very messy title, and we can get it clean, but it takes some time. There's a lot of confusion between a title and a deed. Title is a legal right. It is not a piece of paper. It's just, I have the right to live in my home. I have title. Deed is the document that conveys that right. So real estate title is the strength of your ownership claim. If you have clear title, it means that there's no unexpected claims on the property. That could be a lien on the house. That could be a reverse mortgage. That could be all types of things. A deed is the document that actually transfers ownership to the new owner. What does it mean to have clear title? Most important thing is to make sure the title that you have is clear now. And then what you want to do is file a transfer on death deed. It's the easiest and least expensive way to transfer real estate to someone after you pass. You can prepare a will that is legally valid in Texas to transfer property after you die, but a transfer on death deed is so much easier and less expensive. If you don't have clear title, you won't have access to any of the following. That would be disaster recovery assistance, property tax relief, home improvements, and loans. So when I was at Earl Carl Institute at TSU, we would get very busy after a hurricane or after the winter storm where someone would have severe damage to their home. They would apply to FEMA, or they would apply to one of the county or state programs, and the agent for those programs would come back and say, I'm sorry, but you're not eligible for any assistance. That would be because they didn't have clear title. That would be people who lived in homes that had been in the family for a long time, but that no one had gone through probate or left a transfer on death deed to. In order to get all of the property tax relief that you're entitled to, you need to have clear title. And you're not able to get home improvements or any other types of loans if you don't have clear title. You may not have clear title on any real property, or be able to access financial accounts if you do not probate your loved one's estate. We had a situation just yesterday on our hotline at Texas Law Help, and someone had passed away. He left the house to his wife in his will. She's going to have to probate that will in order to have title to the property. She didn't understand that. She thought, well, he gave me the will. He gave me the house in his will. I don't have to do anything. It's a good will. No, you have to go through that probate process. There's a few different options if you want to use the court system to clear title. If the homeowner died within 4 years, you should probate their will or file an application for administration. You do not have to probate anybody's estate until it has been a few years. So there's some people that, call their attorney right away thinking that they need to start probate. You have some time. You have 4 years. Please don't wait till the end of the 4 years because, like I said, the courts are backed up and there'll be a delay, but you can wait a year. Allow yourself some time to grieve. There are certain exceptions. If you can prove that there was a good reason why you didn't probate the will in 4 years, you can file an application to probate as muniment of title. If this is a more complicated title situation, this happens a lot of times when the original people who purchased the home didn't have a clear title. Something messed up happened because instead of using a realtor, instead of going through a title company, they did the deeds on their own and something wasn't done correctly. Sometimes people live where there's a lot next to theirs that they have always kept up. They've kept it clean. The kids have played on there. They have a garden on the yard. This is another reason you could file a petition for adverse possession. So again, within 4 years, you can file an application for probate or administration. It's a pretty simple process if the will is valid, or if there's no will, if everybody gets along. If someone is going to be difficult, and it is amazing to me what people will be difficult about after someone passes, it can take more time. To probate a will, the judge determines whether the decedent left a will that's compliant with Texas law. If there's no will, you file an application for administration, and the judge has to go through a more complicated process to determine that the person applying is the correct person to administer the estate. If it's been more than 4 years, you can file an application for probate as muniment of title. And to clarify, you can do an application for muniment as title at any time. If the only thing that you have to transfer in the estate is the house, you can do an application for probate as muniment of title. That tells the judge, the only thing we need to transfer is this house. Everything else is taken care of. It's more simple. You do have to go to court, but you don't have to go through the process of administration of an estate. You don't have to have a representative appointed. You don't have to have an inventory filed. This process is only available to those who have a legally valid will. If it has been more than 4 years, everybody has to agree to probate the will. I had a situation where they waited 30 years to probate a will. They only came to me to probate because they realized that they had a cloudy title. Because it had been 30 years, as you can imagine, there were a lot of heirs. We had to track down people all over Texas and in Mexico to get them to agree and sign off that we could probate that will. Once the judge determines that everything is in order, that all the heirs have agreed, that there's no need to do anything except transfer the house, the judge will sign a will, admitting it to probate as a muniment of title, and you will record a copy of the signed order and the will, and that transfers the property to the person named in the will. Adverse possession, most people are familiar with. That's when someone has adversely used a piece of land for a certain period of time. So it's the legal principle that allows you to obtain ownership of a property based on continuous occupation without permission from the legal owner for a specified period of time. The critical term there is adverse. If you have permission to reside at that property or use that vacant lot, you cannot use adverse possession because your possession is not adverse. The length of time varies, but it's usually about 15 years. Sometimes it's 20. It depends. It's a pretty lengthy statute, so it depends on what factors that person has met. A very common way to clear title is an affidavit of heirship. That is something that you can absolutely do on your own. We have the instructions and the form on our website. It is a legal document that is used to give property to the heirs of the deceased person. It's often needed if the person didn't have a will or no one probated the will within 4 years and a muniment of title is not going to work. It has to be signed and notarized by 2 people who knew the deceased person as well as their family history. The most important critical thing is that you must have the full legal description, which is found on the deed. The legal description on the property tax bill is not sufficient. If you don't have the full legal description on your affidavit of heirship, you're not going to have clear title. The affidavit of heirship must be filed in the county where the property is located. There's a filing fee. Harris County, it's roughly between $40 and $50. Other counties are usually a little less expensive. People get small estate affidavit and affidavit of heirship confused because they're both affidavits. And what an affidavit is a sworn statement. You swear under oath that you are telling the absolute truth when you're signing this document, and it is signed in the presence of a notary who stamps it. So it's an official sworn statement. Small estate affidavits can only be used to transfer a house to a surviving spouse or minor children. Another good purpose of a small estate affidavit is if someone had a bank account and they didn't leave a transfer on death beneficiary, you can use a small estate affidavit for that. Affidavit of heirship is the best way to transfer a home if there's other adult children or nephews, nieces, whoever it is that is legally entitled to that home. You can also use an affidavit of heirship to transfer to a surviving spouse. It is less expensive than a small estate affidavit. So if that's the only estate asset, you can do that as well. I always beg people, once you get your title clear, please make sure that you continue to build that generational wealth, that you keep your home in your family. Transfer on death deed is one of the best laws passed in the state of Texas. It's a very simple, inexpensive way for a homeowner to transfer their home or other real estate to somebody else. A transfer on death deed is roughly going to run you about $50. If you probate a will, you're looking at least $1,000, and I'm sure that that is a very low estimate on my part. A transfer on death deed does not affect your rights during your lifetime. You have the right to sell the property, use it as collateral, get property tax exemptions, etc. You can take out loans. It is your house 100%. The beneficiary has absolutely no rights to the home until the owner passes away. The owner can change the beneficiary. The owner can cancel the transfer on death deed entirely. And unlike your will, the deed has to be recorded in the county where the property is located. If you keep the deed in a safe space, in your home, in your safe deposit box, and it's not recorded, it is worthless. So you absolutely have to file it before you pass away. Transfer on death deed is another process where you do not need an attorney. We have detailed instructions and a form that will walk you through the steps of setting up that transfer on death deed. The legal description, just like the affidavit of heirship, has to be obtained from an existing deed. If you use it from a property tax bill, it is not a valid legal description, and your transfer on death deed will become invalid. Another great thing about transfer on death deeds is it protects your property from Medicaid estate recovery. If someone most commonly uses Medicaid to pay for their nursing home bills, once that person and their surviving spouse pass away, Medicaid has the right to seek reimbursement. Medicaid only seeks reimbursement through the probate courts. So if you transfer a house through probate, Medicaid can put their claim in and say, Judge, We spent $350,000 in benefits on this person. We need to be reimbursed for that $350. And then the house will be sold to reimburse Medicaid. Transfer on death deed, your home is protected. It stays within the family and you're able to build generational wealth. We have a lot of great resources. You will get a video, a recording of this presentation that includes these. Texas Law Help is your first step to educate yourself. We do have attorneys online Monday through Thursday, 10 to 2 to assist. For direct representation, there's Earl Carl at TSU, Lone Star Legal Aid, and the Houston Volunteer Lawyers. Legal Line is an amazing benefit. Attorneys are available to answer questions for free. They cannot take your case, but then they can answer your question and determine the next steps to take. For private lawyers, you can use the Houston Lawyer Referral Service. They also have a program. They have a list of attorneys who are willing to charge reduced rates. Thank you so much for your time. I am going to pass this on to Miss Donna at the Harris Central Appraisal District, and I'll wait for your questions after our presentation.
All right, thank you very much. All right. You want to undo your screen share, Miss?
Excuse me. There we go.
Can I start mine, Nia?
I have to stop.
Miss,
Okay.
she's trying to stop.
Sorry for the delay.
Okay.
All right, go right ahead.
Can you see it?
Yes, ma'am. You're good to go.
Great. Well, welcome everyone. I'm Donna Pensick with Harris Central Appraisal District. It's good to be here at this Clearing Title on Inherited Property workshop. I'm going to share with you the Appraisal District presentation. So, property taxes, they support critical local services. Texas has no state income tax. So local taxing units use tax revenue to provide local services, including schools, streets and roads, police and fire protection, etc. Our property tax laws are originated with the state legislature, and the entity that oversees that is our Texas State Comptroller's Office out of Austin. Appraisal district responsibilities, values. We appraise all county property, including residential, commercial, agricultural, industrial, and business personal property. And it is at 100% of market value as of the January 1st date of each year. We administer exemptions. And then we certify the appraisal rolls, the 2025 values, to the taxing jurisdictions for them to set rates accordingly. Important dates for the appraisal annual calendar. Our January 1 is our date of appraisal. Your value is based on condition of property as of that date. May 15th is our protest deadline, or it's 30 days from the date of the notice, whichever one comes later. Protests must be filed on or before the protest deadline for any value change to occur before the values are provided to the taxing jurisdictions and the tax bills are calculated. October and November, that's when the tax bills are usually mailed. In Harris County, billing and collection is handled by our local tax assessor collectors and not by HCAD. February 1st is our tax payment delinquency date. So HCAD appraisals, they're required by tax code to be at 100% of market value. It is overseen by our state comptroller's office. They conduct biannual market value studies of the CADs to ensure compliance. Appraisals, they're conducted by the process called mass appraisal. Value is derived from sales, from our sales comparisons. We're responsible for 1.9 million parcels. And parcels is the accounts. So 1.9 million accounts serving over 500 taxing jurisdictions in Harris County. This is a copy of the Notice of Appraised Value. When your value for the new year is proposed, then we send out the Notice of Appraised Value. You'll see it'll have the notice date. At the top right, you'll have your iFile number and the account number. And there's a link there if you want to use the iFile online protest system. And in that notice, you're going to see you're going to have an appraised value amount and you're going to have a market value. And also your notice will have your protest deadline stated. So you want to make sure you know when your deadline is to protest. On the notice, we have an appraised value and we have a market value. The appraised value is the number used in calculating the tax bills. It may be the same as the market value, or it may be lower because of our 10% appraisal cap, which is on properties with homestead exemptions granted. Market value, that is the value at which a property would sell for to a willing buyer on the open market. HCAD's primary role is to establish an annual market value. Protests are based on the market value. And what that means is when I'm protesting the market value, not the appraised value, unless they happen to be the same amount. But generally what we're protesting is our market value. Exemptions. What are they? How can they save me money? And how do I get them? Property tax reduction or elimination for eligible property owners. They are administered by HCAD. It exempts a portion of the property's value from taxation, primary residence only. And it's used by the taxing authorities in calculating your property tax bill. Exemptions exclude part of your property value from taxes. It is reducing the appraised value before the tax rates are applied for the tax offices to generate your tax bill. Most common residential exemptions are your general residence homestead, your over 65 exemption, the over 55 surviving spouse, disability exemption, your disabled veterans. We have 4 types of exemptions for disabled veterans or surviving spouse, and there's other service-related exemptions. Our general residence homestead exemption. You must own and occupy the home as your primary residence. The documentation required, you have to have proof of ownership. You have to have a Texas driver's license or state-issued ID, and it has to have your primary residence address on it. This provides 10% appraisal increase cap when you have your homestead exemption. There is a $100,000 school tax exemption by state law, and their other exemptions may be offered by various jurisdictions through city, county, special district, and that depends on where you live. The over 65 and disability exemption. For the over 65, you qualify for the entire year that you turn 65. Your disability is the same thing. You will qualify for the entire year that you become eligible to receive disability benefits under federal old age survivors and disability insurance, or you have a physician's statement. Benefits for either exemption. you have a school tax ceiling, or what some call a freeze. Exemptions granted to homeowners with general residence homestead. You're eligible for tax deferral and to pay taxes in installments without penalties. Other exemptions may be granted by individual jurisdictions. Our over 55 surviving spouse exemption. You qualify if your deceased spouse died in a year in which the person had the over 65 or disability exemption. Your surviving spouse must be 55 years of age or older on the date of death. You receive all over 65 exemption benefits. That school tax ceiling continues and is transferable. You're eligible for tax deferral and to pay the taxes in installments without penalties as well. Our immediate residence homestead exemption. You qualify upon occupying a home, example like a new construction, a new build, or homes where previous owners didn't have exemptions on the account. You must apply before the first anniversary of the date the property was acquired. If the previous owner did not have exemptions or the home was never lived in, the exemption will be granted as follows. So the first year you receive this IRE exemption, it's prorated on as of the date that you own and occupy. Then the following year becomes your cap base year where you have the exemption for the full entire year going forward. If the home was previously owned and receiving exemptions, the previous owner's exemptions will remain for the remainder of the applicable year, and then they are removed the next year for the new owner to apply. Our heirship exemption. You'll use the same Form 11.13 for homestead application, but in Section 3, you'll see we have two highlighted questions that must be answered yes or no. Is the property, is the property for the application being submitted for heirship, and do other heir property owners occupy the property? There's other information that's needed, affidavit of heirship or the 50-114-A affidavits. Number 2, the death certificate of the property owners. Number 3, we need a copy of the property's utility bill. And then if there's any citation on the court relating to the applicable ownership of the property, if it's available, we need that as well. This is a copy of our annual homestead exemption confirmation postcard. If any information on it's not correct, like you'll see, they have the exemptions listed, the owner, the mailing address. You do need to contact HCAD and get that updated. These are typically mailed in December to those that have homestead exemptions. So as long as you get this in the mail, you're good. It lets you know that your exemption is active. Exemptions, how to apply. You can use the paper application form and mail it in. We have an online submission of the form itself. We have an HCAD mobile app, and you can email it in as well. Depending on when submitted, the processing time may take longer. It's important to submit everything at once to avoid delay in processing. And once it's applied to your account, you will be notified. We actually send out then a confirmation letter to let you know it was granted, or we'll let you know if there was anything further needed. We also have a how-to video. It's available on our website, www.hcad.org. You'd go to the Forms tab, and it's there under Popular Forms. You could follow along as you fill out the application form if you need it. There's also additional helpful information on our website, and there's videos that have instructional information as well. We do have here at the bottom a caution to be wary of solicitations offering designation of homestead for a fee. This most often happens when ownership is changed. I've seen a property owner get 3 of these, and they target new homeowners and they ask for a dollar fee and a notary, and it's actually unnecessary. It's not from HCAD and it does not help with your tax liability. Acquiring the exemption through HCAD is absolutely free. It's for the property owner and there are no fees or notary needed. Exemptions versus the deferral. So exemptions are similar to like receiving a discount, and our deferral is when the property taxes are deferred to be paid at a later time. Here's just an example of the Harris Central Appraisal District website. We have our tabs there at the top. There's a contact tab, and then at the bottom you'll have different things that you may need information on, your protest options, your exemption forms, etc. To contact us, our physical address is 13013 Northwest Freeway, Houston, Texas, 77040. We do have a 3rd floor walk-in customer service counter. Our general phone number is 713-957-7800. Our website is the www.hcad.org, hcad.org. And then online under contact, that is where you're going to find the web form where you can send us inquiries. So that is my presentation. I've also included my email address in the chat, and I will put that in there again for maybe someone who's joined later. But you're more than welcome to send me an email if you have a specific question on your certain property, and I would be happy to help. So I'm grateful that you're here. Thank you so much, and I will pass this on to Shay.
All right, thank you very much, Donna. Will you guys be on standby? There's quite a few questions in the chat here.
I noticed. It's almost like a final exam question. Some of them.
Okay, yep, you're good, Shay. Did you mute your mic or your headset?
Can you hear me now?
Yes.
Perfect. Okay, thank you so much. So I am Shay Pinkowski, and I'm with the Office of Annette Ramirez, who is the Harris County Tax Assessor Collector for Harris County. A lot of you will see our names on that bill come up to you here in October, November. So I'm here to talk a bit about property taxes, how they're calculated, and what options you might have that you might not be aware of for paying those property taxes. So I'll just go jump right in. This year, we elected a new tax assessor collector who is Miss Annette Ramirez. She is a wealth of knowledge. She comes from a lot of experience with Aldine Independent School District as legal counsel. So she is really well versed in a lot of the going-ons with property taxes. There's a bit more information on here if you'd like to read up on her. But just so you know, whenever you see your bill this year, it's not going to say the previous tax assessor collector's name. It's going to say Annette Ramirez, but it's still going to be the Harris County tax bill. There you go. Okay, so what are the responsibilities of the Harris County Tax Office? So your tax office and tax assessor collector's responsibilities are including the billing and collection of property taxes, which we collect for over 80 jurisdictions in Harris County. We also register and process the titling paperwork for vehicles. So whenever you go to register a new car or renew your registration sticker on your current car, we're the office that you would go to get that completed. We also maintain the voter registrar rolls for elections that come up every year for all public offices. So we do a little bit of everything. Just as a notation that I've been requested to pass along to you folks is whenever you're registering your vehicle this year, please make sure that you are still getting the emissions test for your vehicle taken care of. Previously, we had to do an emissions test and a safety inspection. As of this year, we're no longer required to do a safety test, but we are still required to do that emissions test as Harris County is an emissions state or an emissions county. So just please keep that in mind if you have to renew your registration anytime soon. So as a quick overview, Harris County does maintain approximately 1.7 million tax accounts, which collects over $8 billion in taxes every year. All of those funds are distributed to our 80 taxing jurisdictions that we collect for, and it's dispersed based off of whatever their tax rates are and the taxable value of your property. So that's how that gets determined. But we collect taxes for Harris County, Houston ISD, City of Houston, Harris County Flood Control District, as well as a handful of emergency services districts and MUDs, which are municipal water districts. So depending on where you're located will depend on which one of those are going to be applicable to your property. So in the past 4 years, we've had a lot of property tax changes. So one of the most notable is the increase for your over 65 disabled exemption for Harris County, which is it went from 229,000 to 320,000 in 4 years. The city of Houston also increased their exemption, meaning that you're getting a reduction in what you would normally pay 4 years ago in taxes. For city of Houston went from 160,000 to 260,000 reduced. Your school general homestead for the state actually was reduced as well. So those exemptions went from 25,000 4 years ago to 100,000 this past year, with possibilities of it being increased dependent on Senate bill decisions later on in the year. Um, those homestead exemptions previously, over 4 years ago, were not applicable as soon as you moved into the property, but they are now available as a prorated start date, with that beginning date being the date in which you purchased the property and became the owner of that property. In prior years, you would have to go forward and only apply for that homestead exemption from from the first full year that you had that property, and that's no longer the case. This is what you'll be used to seeing whenever the tax bills go out this year. As you can see here, we have the full image on the left-hand side, which is what your full page of tax bill will look like. It'll show you all of the jurisdictions that collect for your taxes, along with their tax rates, the value in which that they're taxing off of, and how much those full taxes are. And below it, we'll have a payment coupon. And that coupon is what you would send in if you're sending it in to us with a check or by mail, or if you're coming into one of our branch offices to make that payment. We'll be able to have that received and be able to have all of your information for the property taxes. Electronic tax statements. We also have the option, if you were to go online and request for your statement to be sent to you via an email, you are able to request to do so through our website. This emailed tax bill will take the place of your mailed tax bill. So we are required to send you a statement. If you select to have that sent to you electronically, we would no longer send it to you physically. You would not receive a physical tax statement in the mail if you are opting in for an electronic tax statement. So just keep that in mind. It is an option for you if it's something that you would prefer. If you pay more attention to your emails than you do your physical mail, this is a really popular option for folks who are out of the state, out of the country, who travel a lot. This is a good way for them to keep up and maintain with their bills. And you can register for this on the Harris County Tax Office website. So I mentioned this briefly earlier, but just to go into it a little bit further, whenever we calculate your tax bill, we use the values that are provided to us from the Harris Central Appraisal District in determining what the taxable value is. So they would determine what the appraised value of your property is, and then they would let us know what the exemptions are applicable to your account and in what amount. And using those two, we come up with your taxable value. Once we have your taxable value, we multiply it by the tax rate, which is determined by each of the jurisdictions that collect for your property. And as I mentioned before, it depends on where you're located and as to which one of those will be applicable. And that's how we determine how much your tax bill is. That's how we determine that total value. So whenever you're receiving that bill, you'll have all of this information written out, but not everyone is aware of how that calculation kind of works together to come up with your total tax bill. So just as a visual representation of how much your taxes can be affected by just the homestead exemption or the homestead and over 65 exemption, these are estimates based off of a property of $342,000. And as you can see, with just the homestead exemption, you end up saving a little over $2,000 versus with the homestead and the over 65, you can save as much as almost $6,000. So you see that the difference does increase with more exemptions you add, and these exemptions act as discounts. They take an amount off of the total taxable value of your property, so that you're taxed on less, and that reduces your taxes overall. So whenever you're seeing your tax bill, make sure that you're getting those exemptions that you're applicable for, so that you're not paying more on your taxes than you're needing to be paying. In addition to our homestead, our over 65, disabled veterans exemptions, there's also assistance for damaged property in disaster areas. This has to be done when the governor declares a state of emergency or a state of disaster, and otherwise it's not applicable. But we have this on here because last year we had a good couple of storms tear through. We had a derecho, we had a barrel tear through, so it's good to keep in mind for future reference. Neither of those are applicable right now, but for this upcoming hurricane season, you want to be aware and kind of keep this in the back of your mind that if we do go through a hurricane or some other major storm that causes damage in an area, that this is something that you could do in the future. Tax limitations. You'll hear this referred to as several different names, but they all mean the same thing. So you'll hear it as a tax ceiling, a tax freeze. You'll hear tax limitations on occasion. But all it does is it limits the increase of your taxes for your school district and some taxing jurisdictions, depending on which jurisdictions are applicable to you and whether or not they allow for a tax ceiling. What this does is it limits how much the taxes can be collected for on a certain jurisdiction. This does not apply to all jurisdictions. So as I mentioned before, we collect for quite a few. We collect for 80 jurisdictions total. It's not going to apply to every single one of those, but it'll apply to your school and it'll apply to a couple of other jurisdictions that allow for it. Off the top of my head is Lone Star College. But this applies to homesteads of property owners who are over the age of 65. It's automatic. You don't have to request for it. But it does get added onto your account from the first year onto the next one, meaning that first year you won't really see a difference with a tax limitation because that's the year that that limitation is set. The following year, though, should the value of your property increase, the total amount that you would pay for that school tax would not be more or greater than the first year in which you purchased it. So that's what that tax limitation does, is it reduces how much you pay for that school jurisdiction specifically, and it assists you in making sure that that doesn't get out of hand. A tax deferral. I saw a question in the chat earlier about this, is what is something about the difference of a tax deferral and how that's applied, or what the difference is. A homestead exemption, an over 65 exemption, disabled veterans exemption, all of these exemptions are discounted from your taxes. They remove a portion of your taxable value, which reduces your taxes. A tax deferral is a postponement of your taxes, meaning these taxes are still owed in the amount that they are being billed to you. However, when you defer your taxes, you have additional time in which to pay with a lower interest fee per year. So instead of paying your normal penalty and interest fees as you would had you not had the account deferred, with a deferral, you pay a 5% interest per year, and you have additional time in which to make those payments because, with those over 65 disabled or disabled veterans, they have that option of having those taxes deferred. That deferral ends upon the sale of the property or a change in property ownership. Um, and as I mentioned before, it's a delay. It's a postponement of your taxes, meaning you have additional time to pay them, but they are still due. So whenever those should, in the case of someone passing, if they had their taxes deferred previously, then they would have to pay back. Their heirs would have to pay those property taxes that were deferred. So if they just did not pay any of their property taxes, or they left some behind, or they weren't able to pay it all in full, they'll be given 181 days to pay off what was unpaid from deferred taxes without additional penalty and interest. It'll still be at that 5% per year, but once those 181 days are over, you would be paying for all the taxes that were owed, in addition to the penalty and interest fees that would have been accrued at the time of that deferral being placed on the account. So those taxes would be due in a much greater amount after those 181 days. So it is something that you want to make sure that your heirs are aware of when they're going through that process. If you decide to defer your taxes, it's an awesome tool to help you pay your taxes, or rest a little easier, with having to spend all of this money on your property taxes. It does help knowing that you have that additional time, or to just not have that weight on you and be able to tell your heirs, hey, this is what's going on. My taxes are deferred. If you want to pay towards those taxes now, they're at a very discounted rate as opposed to what they would have been otherwise. But make sure that they're aware of it during this process so that you're able to rest a little easier about the afterwards. You are still able to pay your taxes. It's not saying that you cannot pay your taxes, but it does give you that freedom of taking time in which to do that. There's a deferral affidavit on the appraisal district website that you would have to submit in order for that to be processed and applied to your account. And again, as I mentioned before, this process is available to those homeowners for the homestead residents on an over 65 exemption, a disabled homeowners exemption, or a disabled veterans exemption. And just as a quick note, for those of you who check all of these boxes and this applies to you, if you do choose to have a deferral placed on your account and you're making payments towards your house, it's either being escrowed, or you're taking out a second mortgage, or you're still making payments on a new property, please make sure that you speak to your bank before you go through with this process, as not all banks will be accepting of a deferral being placed on their property, as they have a interest in the property. In order for them to receive their money, they are required to ensure that the taxes are being paid, and you might be escrowed anyway. So they might still pay your taxes for you, and then in turn require that money be paid from yourself. So please make sure that you take care of that, and make sure that you contact your bank before applying for any deferrals, just to ensure that that isn't something that would happen. Aside from the deferral and exemptions that we have available, we also have the option of having a payment plan applied to your property. This does not have to have any specific type of exemption. This is not required to any specific type of property. This is something that is available to all property owners, including business personal property, and is used as a financial planning tool, meaning that it still collects your property taxes. You'd still collect penalty and interest. However, it does protect you from litigation and further attorney's fees down the line, so long as that payment agreement is put in place prior to any attorney or litigation fees being placed onto the account. So there are two options. One would be a homestead plan, which allows for an extended payment agreement time. You can have that from 12, 24, 36 months. And the terms include a 1% penalty, 1% interest per month, plus the initial penalty of whatever month you create that payment agreement in. So in February, that would be 7%, and then 1% every month thereafter until it's paid off in full. For all other accounts, this would be non-residences, business personal property, commercial property, land. These are available for a 12-month payment agreement. and you do pay the regular accrued penalty and interest, but it again saves you from possibly having those attorney's fees or those additional litigated fees placed onto the account, so long as you're able to create that agreement prior to those fees being placed on in the first place. And that's coming up the end of this month, where all of the accounts are going to be turned over to our attorneys here at the end of June. So if you haven't already, please make sure that you contact our office in order to help you get set up on that. And we'll be able to hopefully get you set up and ready for your payment agreement to start taking place. Payment agreements require that a payment be made monthly in the minimum amount in which you create that agreement for. And they are due at the end of each month. So whether that is, upcoming on the 30th, this would be the 30th would be the last day to make that first payment for your payment agreement if you have not set one up already. And that's whether you start it now or that's whether you start it on the 30th. In addition to regular payment plans that we have for all properties, we also have something called a quarterly payment plan. Quarterly payment plans are applicable towards homesteaded properties of over 65 exemptions, disabled homeowners, disabled veterans, and surviving spouses. And this helps you by splitting your total amount due for your property taxes at the base levy in January. And you can split that into 4 equal payments and pay over the course of January, March, May, and July. So this helps because you do not have to pay penalty and interest when you are on a quarterly payment plan. Unfortunately, since it's so late in the year, it's not going to be very frequent these days that we'll get a request for a quarterly payment plan unless you were just certified with your bill recently. So keep this in mind if it is something that you're still in the process of waiting for your tax bill, which it shouldn't be for very much of you. But if that might be the case, just keep this in mind that it is an option for you. We have multiple payment options available, including paying online, by mail, over the phone, and in person. Please keep in mind if you're going to be paying in person or online or by phone, that if you're paying with a card, whether that be a debit or a credit card, there is a 2.45% fee that we are required to charge by the bank. This fee is not something that we have control over, so just be aware that it is something that gets applied to your account automatically. If you're making this payment online, you do have the option of paying with something called an electronic check or an e-check, and that electronic check would assist in avoiding that fee. So you would not have that 2.45% fee so long as you're making that payment through that electronic check. We do have several offices that are available. We have several branch offices that are available to assist, take payments, and assist with questions. But we are here to help. If you cannot go into a branch office to assist for assistance, we also have our website online, which has a lot of information and very useful information regarding your property specifically. You can give us a call and speak to one of our representatives over the phone, or if you'd prefer to send us an email, we're also available via email for you to reach out to with any questions or queries you might have for your property. We are here to help if you have questions or if you're just unsure of something or not something does not make sense. Please feel free to reach out to us and we'll be able to assist you there. That is the end of my presentation. Nia would be coming up here soon. But I'll go ahead and
I'll go back through the chat and
yes.
and review the questions. Okay. Miss Lisa, you there? We're ready to go. Okay. This question is, how long does someone who lives in a home have to transfer the title or deed to their name? What is the process to change the inherited property in Houston with a will or without a will?
With a will or without?
Both. The question is for both.
With if you have a will, if the person who owned the house had a will, they should probate it within 4 years. If they haven't and they can prove to the court that there was a very good reason why they hadn't, they can probate it after 4 years. Otherwise, at any time, you can do an affidavit of heirship, will or no will. Honestly, I'm sorry if I go through so much information in a short period of time. The best way to answer that question is for you to watch the recording when you receive it later today or tomorrow.
Um, Okay, and then you've already gone over the pro bono services that are available, the various legal partners that we have with Lone Star Legal
Yeah.
Aid, Houston Volunteer Lawyers, and the Earl Carl
If
Institute.
if you need assistance with clearing title, the absolute best place, and they take Harris, Fort Bend, Galveston, Brazoria, Liberty. I am forgetting one. They take Harris and the 6 adjoining counties, and that's the Earl Carl Institute. They specialize in clearing title. With Lone Star, it is not a higher priority, and they are legal aid in general in Texas is very low staffed. There are 10,000 people who qualify for legal aid for every one legal aid attorney. So it's a real need in the state to have assistance with probate, because a lot of the legal aid, they have to deal with very critical situations, and they don't consider, critical to them is dealing with getting someone out of a dangerous relationship. Critical is helping someone with a divorce that's urgent. They don't see this as critical. And there's nothing on that. Everybody has different priorities. I'm not criticizing them at all. But the best thing would be to call Earl Carl. They are small. Sometimes they have to close off intake. You can find out when they're going to reopen it. Apply to Houston Volunteer, apply to Lone Star, but know that they're more limited in the kinds of case and that type of case.
Okay. I don't want to get into too much detail with this question, but Shay, if you could just answer it really quick, because that's something that it is discussed in the foreclosure workshop. What happens when requesting a surplus from property tax sales when all heirs are in agreement? Is a lawyer required?
So as far as for them to receive the fees from surplus sales, that's not done on the tax office side because tax sale is done by the constables for the precinct. So they're the ones who actually receive those funds. And the tax office is one of the units that receives payment for those unpaid taxes during the tax sale. But as far as any overage of those funds, they would want to reach out to that precinct to see for additional information as to where they would receive those funds from or how they would need to go through that process. Unfortunately, it's just not something that I have a lot of information on.
Okay. All right. What should family members do if the last executor of an estate or a trust established in it was established in California, but which included heirs' land in Smith County, Texas? The executor passed. Uh-oh, I went too fast. The executor passed about 2 years ago, and our resources are limited. Is there a way to finally just separate the land so that it's no longer under the trust?
I want to tell you, I'm really sorry that happened to you because that's an incredibly complicated issue. I cannot answer that question because I don't know California law at all, and that's a question that involves California law. I apologize for that. They shouldn't have included Texas land in a
Texas
California
property.
trust.
Yeah.
But you're going to need to reach out. What you could do is call Houston Lawyer Referral Service and see if they know anyone who's licensed both in Texas and California. That would be ideal. Otherwise, I can find I'll take a second. I can find our counterpoint in California. Every state has a law help website, and I can find that counterpoint, and they probably have resources for you.
Okay. What if you apply for administration and are anywhere within that process, and then you find the will? What happens then?
You need to let the judge know that you found a will. You let your attorney know first, and the attorney will let the judge know, and they can convert it from an administration to the probate of an estate. And you absolutely should do that. I mean, it's your legal duty to report it to the court.
Even if it's been more than 4 years.
Yes.
Okay. On the Texas Law Help, on the Texas Law Help's website, Are there forms for approved forms for revocable living trust?
No, and there never will be. I probably should do a whole nother presentation on wills and trusts. And trusts have the greatest PR agent in the world because everybody wants a trust. Not
Everybody.
that many people need trusts. We wouldn't have that because we would never recommend that someone do something that complex without a lawyer. I absolutely would never ever recommend using an online resource. I just found out from someone who came to our hotline that they used a website called Trust. It was either, I think it was Wills and Trust to draft a trust. They gave him a fill in the blank trust. They did not do any of the work to transfer the property to the trust. A very common problem. People think all they need is this trust. So you get a trust from a website. If you don't transfer your property to that trust, that's just a very expensive piece of paper that you got there. And if you go to an actual law firm, it is very expensive to get a trust because what they do is they go through the process. They get a spreadsheet of all of your assets and transfer all of those properly into the trust. So it's a very complex process, and I could never recommend someone doing it themselves.
Mm-hmm.
And if you want me to do a will and trust, maybe we should put that on the schedule for next year.
Yeah, because we get so many people, and and the fact that I wanted to make sure that we reiterate also is that a lot of times you get these TikTok videos and Instagram messages and things like that. And you've got people that are posting blanket kind of statements for something that does not even relate to the state of Texas. And you got so many
Yes.
folks that are out there putting information out about trust, and you got to have a trust. So that's all people hear, and that's all they think, that they have to have a trust, which means that the trust will completely help them avoid probate and fix all of their problems, and that's not the
It
case
is
at all.
absolutely
So
not true at all. And one of the things that's very confusing is Texas probate is not as expensive as it is, say, in California. And there are other states where it is better to avoid probate. That is not true in Texas. If you have a good will, or if you do what I say and you have a transfer on death deed, you have payable on death beneficiaries, you don't have to deal with probate at all either. Just as a quick aside, for the person who had the question about the California trust, go to the website lawhelpca.org. And I'll try to find them in the chat so I can reply to them there too. But
okay.
in basics with wills and trusts, there are a couple of very good reasons to have a trust. There are people that want to protect their assets and they don't want it all to go to a nursing home down the line. They want to make sure that their assets go to their family. They want to, build that generational wealth. You want to go to somebody who is an elder law specialist who can protect your property by putting it in a trust. If you have a blended family, you might want to have a trust. So you make sure your kids get your things. But for most of us, you really don't need one.
Let's see. If I file a transfer on death deed for my son on a home that I purchased in Harris County, does it still transfer if I have a mortgage on the property at the time of the death?
Absolutely. Any money that you borrow, again, whether it's a mortgage, a home improvement loan, a reverse mortgage, anything like that, debts stay with the land. So you can absolutely transfer your house that way. Whoever inherits it will be responsible for that mortgage.
Okay. And does it apply to income or investment properties as well as primary residence?
That I,
Todd.
Todd, yes, you can.
Okay. All righty. For HCAD, another question about trust. If I place my home in a trust, will I still, and I still live in it, will I lose my homestead exemption?
I answered that in the chat, actually. So what I said is you can put an account in the name of a trust, but we cannot grant exemptions to a trust. But however, there are property tax code laws that help with this type situation. And the trust must have the legal language that you may occupy the property as your primary residence rent-free. And if the trust has that, and like Lisa said, you literally have to have the property transferred into the name of the trust. What happens if it's your primary resident and you have exemptions? There are certain documents we need to reinstate your exemptions. So we can't grant exemptions to an ownership of a trust. However, because of the property tax code law, you get the account in the name of the trust, and then you have to reapply to have your exemptions reinstated. So what we need is like the application, your driver's license, and we need a copy of the trust, especially the part that says you may occupy rent-free. So, and you don't have to give us the whole trust, the first page, but we have to clearly see that you can occupy rent-free and then the sign pages. But, and then what we do is we put the account back in your name. We put the trust in the mail to, so it's documented that it's in a trust, and we have the trust documented on the account. So then we can reinstate your exemptions so they can remain. So
Contact a lawyer to get it done.
Donna gave an
yeah, a trust is very complicated. Yes.
Donna gave an absolutely perfect, excellent answer. I've been in public interest law for about 6 years. Before that, I was in private practice. And this is one of the reasons why trusts are very expensive is it is so easy to mess up your clear title by doing a trust, by doing a deed yourself. So part of what the lawyers do when they prepare the trust is do this very complicated process of making sure you don't lose any of your property tax exemptions. Because if you do it yourself, you'll mess it up and you'll lose those exemptions. So that's, that's one of those things. Well, they say penny wise, pound foolish, where, well, I can get this trust online for $200. The lawyer's going to charge me $5,000. You're going to lose $5,000 in property tax exemptions if it's not done correctly. Probably more.
There was a question that was asked during your presentation, Lisa. So I'm not sure if where exactly in the question that, or where in the presentation that the question was asked about. Does this all change if the land has been in the family for generations? So I don't know if the person that asked that question wanted to unmute themselves and kind of chime in on where exactly that what exactly that question pertains to. So I'm not really sure.
Yes, ma'am. That was, excuse me, that was me. I was wondering if I like that the transfer on death deed. And for the most part, there's just me and my son, but then there's also that heirs property off to the side. And I just wondered if it will apply to if I could do that for everything with him, just do a transfer of deed form for even like land that I have separately. I'm not living on it. I didn't know if some of these things like the exemptions or the transfer of death didn't apply if it's not like your primary home.
You can absolutely do a transfer on death deed for something that's family property like that. You don't get exemptions because it's not homestead property for
Okay.
property taxes. The one thing I would caution you with heirship property is if multiple family members own it, you need to have a very clear description of the land that you own. And it would just be it wouldn't be the entire legal description. It would be a fraction, it would be a whatever percentage interest.
Mm-hmm.
So that's something that I would not want you to do yourself.
Okay.
I would want to make sure that you had someone who could look at the deed for the heirship property.
Okay.
Yeah,
I will, I'll reach out to you separately anyway.
Absolutely. I have my email
great.
address in the chat, and I think I am included when Nia sends out the email with all the information. My email address is on there.
Okay, good deal. Can I ask one more side question? I think maybe other people want to know is I also had with my father, one of the family members, like you said, people can be untrusting. Someone turned in documents to ancestry.com as if he were deceased, and
Oh
he's not.
no.
He's here in a nursing home, and I did submit that, but Ancestry hasn't contacted me. That can't be used in law to try to prove him being gone or that others would be heirs, can they?
Legally, no. You have
Okay.
a very valid concern there, and it's upsetting that somebody did that. I'm sorry that happened to you, but they could not use it to go to a court or something like
Okay.
that. That's not um, legally sufficient evidence at all.
Okay. Good to know. Thank you again.
Oh, you're very
Oh,
welcome. Thanks for your
I
good
I
questions.
will I will include the title fraud in the deed scams link presentation in there for you to go back and look at too, so that you can see how some people use unlawful practices to commit those kinds of acts.
I
Thank
have
you.
been doing this type of work for a long time, and I learned things at the title fraud presentation, and it's alarming how easy it is for somebody to commit some of those scams.
Is the Medicaid rule the MERP only for skilled nursing?
That is a great question. Honestly, I do not know. I believe in general it is. Um, we have a program at our office that is for Texans over the age of 60. They would know that answer, and I can put that in the chat. It's the hotline for Texans, and I'll get their information, and I will actually get it to Nia, and she can include it in that email because they know Medicaid much better than I do.
And I'm almost positive in one of the previous workshops, I thought it was anything that Medicaid actually pays for that they can reimburse, regardless if it was uh, skilled
That could be true.
care or not. So,
That could
but
be true. I
definitely
used
don't
to be
quote me.
Medicaid certified. I'm not anymore because I'm not in private practice, so I'm not going to answer that. But I think in general they would go after the house because that's what most
The
people,
big,
that's their
okay.
most valuable asset. That's where they can get that. So it could be true.
And then Shay, you reviewed the question about deferred property taxes.
Yeah, but just to kind of go over it again, what constitutes a deferred tax, and is the homestead exemptions or veterans exemptions, or is that something that has to be paid off after someone passes away? And just to recap it all, it's a postponement of taxes. Deferred taxes mean that those taxes are still owed, they are still going to be due, and they would be due in full upon the passing of the person who had that exemption on that property. The exemptions don't go away. So even if they did pass away for that year, they would still have those exemptions on the property. However, after that, after the year in which they pass, those exemptions would no longer be applicable to that property because that person who had those exemptions is no longer living there. So that no longer applies, and HCAT can go back and get those removed 5 years. Donna, is that correct? Yeah, 5 years. So just keep that in mind. They're applicable, those exemptions are applicable for the full year of the year in which they pass. The deferral must be paid off within 181 days of whatever those deferred taxes were in order to avoid those additional penalty and interest fees, other than the 5% that would have been applied with the deferral active. So separate things, but it's good to know either way.
Gotcha. All right. How long do you have to be a resident in Texas for you to claim the homestead exemption?
So before you had to live in a property for a year in order for that exemption to be applicable. Now they do from a prorated start from whenever you come into the ownership and start living in that property. Donna would probably be the best one to answer that though.
Yeah, I answered two questions there in the chat. So you may only have one homestead property with homestead exemption on it in any certain year. Once you own and occupy the property, you may apply for your exemptions. You must remove them of any prior residence that has exemptions on them. You want to be sure the ownership is in your name. You apply, you complete the application form, you submit a copy of your current driver's license with the new address, and exemptions are not transferred automatically. People, don't realize that. So you remove the exemption off one property and you apply at the other. So we have forms for both of those things on our website And so you can only have one exemption, homestead exemption on one property in one certain year. So,
Okay. Ms. Lisa, this will be for you. Someone sold property to a family member that did not go through a title company. Mistake number one, never, ever, ever, ever purchase property without going through a title company for this very reason of the second part of this question. Later it's found out that the title was not clear. One estranged family member who was on the deed also. The family member wants monetary reimbursement for the property before they sign off on anything. What can be done?
You've got a big problem. And, this is people, every time we have the hotline, we get at least one question about where do I find the forms for deeds. We do not have forms for deeds, except for we do have for the transfer on death deed. That's it. Anything else, you want a lawyer. You want the title company to prepare it because it is so easy to mess those things up. Deeds are very tricky explanations. So I get really sad that, this is another penny wise and pound foolish that that's just this piece of paper. I can just do this deed. And it's going to lead to problems down the road if someone didn't prepare it properly. You need, if it's in the service area, call Earl Carl Institute. They can help you. There's a couple of different options. It's not something that you can easily clear up on your own. You will need a lawyer. Apply for Earl Carl. If they're not able, call the Houston Lawyer Referral Service. They're going to have to do a correction deed, and it will take some time, and it's a lot of legal work to get that cleared up. So please, I know lawyers can be ridiculously expensive. I hate that. I hate when I have to tell people your only choice is to call a lawyer. But lawyers are trained for a very specific reason so that they won't make these kinds of mistakes.
Okay. For bank accounts, I recently had an account holder that did a transfer clause and person identified. The bank refused to answer any questions without a letter of administration. They did not even look up the accounts. Oh, this is just an FYI. So yeah, you'd have that the bank won't talk to you or give you any information about anybody's accounts without letters.
That is correct. If you are named as a transfer on death beneficiary, they are supposed to talk to you and transfer that to you, but they legally cannot talk to you. Can't go up to my loved one just passed away. I'm trying to get their affairs in order. They're not allowed to talk to you without those letters.
Okay. Scrolling down here. Will residents need to go to Harris County for anything related to these new school choice vouchers, perhaps show ownership or how much tax they paid over to this? I'm not familiar with any of that part.
It's the new school vouchers. I don't know when they go in effect. And
It's for private schooling, isn't it? From what I understand. Yeah.
It's the ones where people, instead of sending their kids to public school, they can get a voucher to use that money at a private school. And I think that's an interesting question. I don't know that we would even have that information yet.
For Harris.
Oh, go ahead.
No, I'm sorry. I was going to say, on our end, usually our documentation is not enough to prove ownership of a property or like presence of a property because you could own a property that's nowhere near your place of residence, and it doesn't necessarily mean that you live there. It doesn't necessarily mean that you don't live there. So just on the Harris County Tax Office side, it's not something that I would recommend as like proof of ownership for anything. While it does appear in like public records, I think if they're asking for any kind of ownership information, that it should be something like, a copy of that deed or I think even like depending on like DPS and such, they'll require, mail addressed to you that was sent to you to that address. So it's really something that you might want to look into a little further for that. But usually the tax office and the tax bill, because it's public information, it's not something that they would consider to be proof of ownership.
And that's a really great point. Just because your name is listed as the owner on the property tax on the county property tax office, that does not mean you own the property. You know, I've had this come up quite a lot where it's usually with airship property where there's one heir that really wants to make sure to save the property. So they go, you know, they get their name put so that the property bills are sent to them. That does not prove that you own it. And that doesn't mean that you own it either. You need to go through the legal process.
Okay. For a property owner that is going through a tax suit for delinquent properties but still making payments, how likely is it to get the attorney's fees waived or reduced to provide some relief of the financial burden of paying both?
You are not going to like this answer. Because of how the taxes are collected, the only way that you can avoid attorney's fees is by creating that payment agreement and being timely and maintaining those payment agreements. So if you're able to do that before the attorney's fees get applied to your taxes, then, we're able to stop a further litigation and further attorney's fees from being added on the tax side to your account. However, if you're just, consistent in making a payment, but it's not under any kind of agreement, it's not under any terms that have been determined and agreed upon by yourself and the tax office, it's not something that we are able to step in and request for those fees to be removed from the account because those attorney's fees are whenever we um essentially hand over your property tax amounts to be collected by our collections attorneys. So it's not something that we can, um, unless it's an error on our side and it meets certain requirements, that penalty, interest, and attorney's fees normally would not get removed. So if it's something of the nature of, extenuating circumstances, sickness, unfortunate things happening, it's not something that we have any personal control over. It's something that we have to abide by per the tax code in order to um, even recommend a waiver of penalty, interest, or attorney's fees. So it really does depend on your situation. And I can't say it's like a likely or not likely scenario because every situation is so different that there's no way to compare apples to oranges to kumquats. So it's just not something that we can answer to that. Um, Particular phrasing. If you have a question, then I did put our information in the chat as well if you'd like to reach out to us about your specific situation, and they'll be able to look at it and hopefully be able to assist you in, whether or not that's something that can be done. But as far as, having those attorney's fees removed, it really does have to meet requirements of either you want a payment agreement for the account and those attorney's fees were added in error, or that the penalty and interest was added to an account that shouldn't have been added, penalty and interest. It does have to meet certain requirements for that to go through. So
In regards to payment arrangements, are payment arrangements only for that particular tax year? So, or do you
no.
have to do one for each or do a new one? So say, for instance, if somebody all owes for 2024 property taxes, but they still already owe for 2023 and they were already in an arrangement, how do they then make arrangements for 2024?
So currently we're still going based off of COVID rules. This is the last year that we're doing it. We're no longer going to be able to do this, so I don't like to mention it, but I'll mention it in this case because it's phrased to me this way. COVID rules were if you have a payment agreement for previous tax years that you have not paid off complete to completion, we were able to roll those taxes together. So if you were already in an agreement for 23 and then 24 came around and you still hadn't paid 23 off and you still have a bill coming for 24 now, we were able to combine all of those tax years delinquent into a single payment agreement and then just have you pay on that. Now, prior to COVID and this upcoming tax year's rule is completely different. If you are on a payment agreement, you must complete that payment agreement before beginning a new one. So say I have an agreement for 23, 24 taxes, which is this year and the year prior to that, and 25 taxes come out here in November of this year, and they'll be due by the end of January next year. So 25 taxes are going to be due. I have to be sure that I am continuing with my payment agreement for 23, 24. And in addition to that, I have to ensure that I am either saving money or prepaying money in order to have my 2025 taxes taken care of. because at this point, we won't be able to include your 2025 taxes into another agreement along with prior years. And the only way that we'll be able to include 2025 taxes into a payment agreement is if all prior years are paid or all prior years, or there's no prior payment agreement on the account. So this upcoming year, we're not going to be able to roll everything together. So if you have agreements for 23 or for 2024 and prior years, please make sure that you're making those payments and that you're also planning ahead for next year and come January to pay either all or as much as possible to your property taxes for 2025 so that you get hit with less penalty and interest, but also so that you would hopefully avoid that additional attorney or foreclosure action from not paying taxes, because that's not something we'll be able to assist with unless all years are, again, either paid off or not in an agreement.
For payments, if an owner wants to pay towards the oldest year, how can that be noted for online payments? Or does the owner have to call and have the payment moved? So if they send in a payment, it's been applied to 2024,
So
but they want
online, yeah, so online gives you the option when you're making your payment of selecting where you're having those payments applied to. It'll allow you to either pay to prior years or it'll let you pay to current. So in this case, 2024. If the payment's already been made and you'd see that it's in the wrong spot, we do have a form that you would have to fill out and submit to our email addresses in the chat box. It's called a research request form, and that's what my department specializes in. We would be able to move those payments according to where you would like for it to be applied to. Just please keep in mind if it's, several payments that you're making that have been being applied to the wrong year, that because you're paying to a more recent year, you may have been paying more onto what is the base levy without penalty and interest. Because say if I made a large payment in January of this year and it went to my 2024 taxes, that payment would have been applied to 2024 taxes in full without any penalty and interest, right? Whereas if I was intending to pay to 2022 taxes are being paid with penalty and interest as per that year, depending on your agreement. So just keep in mind that you might see a difference in what's being paid, and you might end up paying more because of that change.
Oh, because if you go back and apply it to the old one, but then that
The
makes
old
this
ones
year's
have,
now. But
right,
now this year is now subject to penalties and interest because it's now wasn't because the payment's
correct.
been moved. Okay,
Yes.
gotcha.
So just keep that in mind whenever you're doing this, that our office is really, my department is really good about making sure that if it does change how much your total amount due is, that we let you know, hey, this is what's happening. If I move this money, this is going to happen, and this is how much you're going to owe in total. And we confirm first, but just be aware that that is something that would happen if you were to move it from, like, say, a currently paid off year to a previously owed tax year that is collecting penalty and interest. And then 2024 would also collect penalty and interest where it hadn't before. So just keep that in mind.
Is a TOD needed for a deceased person's automobile? You're on mute, Miss Lisa.
Sorry about that. The DMV has a different document for transfer of death for a car. If the person is still living, there is a document that they can fill out to indicate who they would want to inherit the car. If they've passed away, there is a form you can use that's an affidavit of heirship for a motor vehicle.
And
I believe that's all included on the email that you'll get.
Yes. Aunt and uncle were married. He passed away. Both names were on the deed. What needs to be done to what needs to take place to remove his name from the deed and the title, or how to clear title?
You have two options. If he did not have a will, because she is his surviving spouse, she can use a small estate affidavit. She can also do an affidavit of heirship. I would recommend the small estate affidavit over the affidavit of heirship, which is still something she can do without an attorney if it's here in Harris or in Fort Bend County. As long as he didn't have a will, that's the easiest way to do it. If he had a will, you need to talk to an attorney.
Joint property question. Mom and stepdad are on the deed. Stepmom died 2014. Dad died 2025. Dad never cleared her name from the title. Is the title based on the dad's ownership since he died last, or both?
If there was never any probate, it's based on both of them. This is a common confusion. You own a home with someone else. Say you and your spouse own a home equally. One spouse passes away. If you do not probate that estate, whether it's a small estate affidavit or probating a will, that person's estate still owns the property. It does not automatically transfer to the surviving spouse. So, I've had a lot of situations where people are, I can understand why it's confusing because it's the family house. Both of them owned it. People will wait until both of their parents have passed before coming into probate. We have to probate both of the wills. We can't just probate the one who passed most recently.
Mhm. That's something that we kind of talked about Tuesday as well, about how you're legally entitled to the property when it's the married couple, but there's that process that you still have to go through. People just automatically assume because you're married that, oh, the house is mine, I don't have to do anything. And that's not the
true.
case.
Yeah,
So,
we get that question all the time. When we were at our last coffee and conversation, someone came up to talk about that. And whoever I think it was Miss Mabel, they were talking to HCAD, and her husband had passed some time ago, and they thought everything was fine. And Miss Mabel said no, and so Jesse and I both, Jesse is from Lone Star Legal Aid, and I explained to her, you still have to go through that legal process to own 100% of the house.
okay. Do TODs really protect your home from Medicare repayment?
Yes, absolutely. It's Medicaid, not Medicare. Medicare will never seek reimbursement. That's something that our taxes have paid for. But for Medicaid, yeah, absolutely. I was just at a program given by somebody who's an expert in this, and he said Medicaid has made it clear that they will not go after the home if there's a TOD.
Okay. Somebody says, yes, definitely do a wills and trusts workshop.
We'll put it on the schedule when
We'll
we open it up.
we'll
We'll
look
start
at
working on it.
Yeah. Okay. Let's see. What should family members do if the last executor of an estate/trust? Oh, we already did that one.
There's a new one that someone just added.
Um,
It's way at the bottom.
okay, hold on. Legalize. How do property taxes change from an elder person with homestead exemption to a younger person already living in the property if they transfer title and deed a few years after the death of the elder family member?
The family member, the younger family member needs to put in an application with HCAD. They will be entitled to homestead. Now is documentation they have to send to prove that it's their homestead. They do not get that over 65 exemption. It's important that they do this as soon as possible. There's a lot of people that want to sneak by. Over 65 exemption is really nice. You will eventually get caught and it'll be a very expensive penalty.
Well, and then there's that other part to that question that it's been years since the elder passed. So that means from the time that elder passed, that exemption left when the elder passed. So all of that exemption that was gone.
Yeah.
Oh, am I frozen?
Oh,
You're fine now.
You're fine now.
Oh,
It was
so
quick.
Shay, can you elaborate on that? Because I want
Yeah.
to make sure that she's aware of that.
Sure. So because the elderly family member who lived in that property and had those exemptions on the property has already passed for a couple of years now, I'm going to assume that it's more than 5, just based off of the verbiage. But the Harris Central Appraisal District can remove the exemptions going back 5 years, meaning that if you're only just now going through and changing it and they see that on the death certificate that they have been that they have passed away over 5 years ago, they'll go back to those 5 years and remove the exemptions from those 5 years. Now, that would make it so that originally, if you haven't already applied for the homestead exemption, I'm not sure which would take precedent and whether or not they would have the exemption applied first and then have the uh, over 65 removed, or if they would have to remove it and then go through the process of adding that homestead exemption to it afterwards. which is more likely the case, but they'll have to pay the taxes for the property without that exemption with those changes that were added on for those 5 years or however long that they've been deceased, if it's less than 5 years.
Thank you. It'll be 2 next year.
Okay, so they can go back 2 years. Oop, I'm turning green.
Yeah.
But they can go back 2 years to show what the differences would have been for those property taxes, meaning that if it's something that you have already kept on the account and currently your bill is showing that it has that over 65 exemption, even though she's no longer they're no longer living in that property. Those exemptions, once you go through with the appraisal district and have those removed, they'll remove it for those 2 years from the first full year after they pass. Donna, am I correct in that?
Yeah, that they'll go back the 2 years then and remove from the death certificate, right? Is that what you're?
Right. Yes. So from that, she said 2.5 years. So would that
Well,
take
so
place?
Well, the
yes,
year that they pass, the exemptions would remain that year. But
So
when
those 2 years
when
then.
we change it into the name of the estate in that year, that next year those exemptions are gone. So then that
got
goes
it. Yeah.
yeah,
So we're in that second year.
Okay,
Like I'm
so
within it. I'm within the second year. Like it hasn't been 2 years. It's been a year and a half.
then it would be a year. So
year.
this past year,
Okay.
2024's taxes,
Mhm.
once they get corrected with the appraisal district, they'll have the exemption removed for 2024, and you're going to owe the difference of whatever the original amount due was versus what the new amount due is with that without that over 65 exemption on the property if you've gone through with the process of applying for that homestead. If you have not applied for that homestead and they have not taken that out yet, more than likely when they take off that over 65, they'll take off the homestead as well, and it'll be just flat, no exemptions applied to the account for 2024, and then whatever the amount will be when the homestead comes out, then if there's a difference and it gets reduced, you'll get a refund for whatever overpayment was made. But um,
So
for
what
that
time?
first,
Yeah. So sorry. Go ahead.
no, I'm sorry. So for that first like in between stage of prior to getting your own homestead exemption and after the exemption for your deceased relative had, there's going to be a point in which you're paying full taxes, no exemptions applied to the account. And if it gets changed with the homestead exemption for yourself at a later time, then they would be reduced and you would get a bit of money back. But
So
per
therefore, do I have to wait until the property is transferred to me to apply for homestead, or can I do it
You have to.
ahead of time?
So that would have to be
Have to.
done through the appraisal district. They would have to, you would have to show ownership. I think they have something different for heirs. I've
I was
kind
about
of,
to say the airship, would she qualify for the airship exemption until the property is then in her name before she could apply, Donna?
Well, didn't you say that you have the official document that transfers the property into your name?
No, at this point, we're looking for the documents. I haven't applied for anything or gone into probate. I'm just trying to figure out what to do next, but I've been living in the home the whole time.
Okay, so that the account, like what we've talked about, it has to have like that recorded affidavit, airship, so that you can, apply for your exemption if you've been living there. But eventually you want, and then that's what you would do with the airship exemption, where you answer those questions, you do the affidavit of airship. Am I right, Lisa? So yeah, affidavit of airship, and then you have to do the utility bill, and then you have to have a driver's license that you live there. So I definitely would get the exemptions removed. And you do that by submitting the death certificate. And then that gets changed into the person's estate. And then the following year, those exemptions are removed. And then do the affidavit of airship and do all the documents that you need to apply for your airship, the homestead exemption.
Thank you.
You can
Can she,
absolutely do the affidavit of heirship on your own without an attorney. I recommend applying with the Earl Carl Institute. I'm not sure if they're taking cases right now. They have someone on maternity leave, I believe. But start with Earl Carl, try the other legal partners, and if you need to, you can do the affidavit of heirship on your own. It's not the most simple process, but you don't need to be an attorney to do it.
Thank
now,
you.
in regards to this particular situation, could she do these simultaneously, or would she have to wait until the death certificate is submitted and all that kinds of stuff before she can do the affidavit of heirship?
She doesn't have to wait. She could do it
Okay.
now.
Okay, so that's what I was trying to think, because if
Yeah.
by the time all of that gets done first, then there's no telling how much time would have passed before the the exemption comes
heirship
off and
exemption would be
Yeah.
applied.
all that stuff that'll be applied.
What I would
And that's,
recommend is following
uh-huh.
what Donna and Shay said, and
Uh-huh.
sending in the death certificate, submitting it to HCAD so that process gets rolling. Once you get that rolling with HCAD, then start working on the affidavit of heirship.
Yeah.
Just
So
kind of
then
keep
I can, yeah, so then I can I also just come in and bring the death certificate to HCAD and say, like, I'm in the process of trying to find someone, or like securing a lawyer for the whatever for the title
Affidavit.
transfer
If you,
affidavit. Yeah.
if you go on our website under the forms, under corrections, there's actually one for changing ownership. And you can
Mhm.
actually fill that out and submit the death certificate online. You can come into our office on the third floor. We have a walk-in counter and you could submit it there. So it's basically
Mhm.
just the copy of the account information and then the copy of the death certificate. So that's what HCAD needs. And then
Got
the
it.
account goes into the name of the estate the year that the property owner passed.
Okay. Thank you so
just
much.
Yeah, just keep in mind that, if even if you don't submit it eventually, the appraisal district does get those records from the county clerk. So even if, say, like, folks will ignore it and they'll just carry on and not submit the death certificate or any kind of information about change of ownership, and think that, oh well, I'm getting the exemption, so all is well in the world. Um, when they find it, they do go back. Even if it's 5 years, they'll go back and take those exemptions off. So it really is something that is best to just kind of stay on top of and make sure that you're submitting all the documentation you need to send in. Because even if it hurts now, it'll hurt a lot more later if you don't. So just, kind of
Oh,
keep that in
absolutely.
mind.
Yeah.
Yeah, it piles up really quick, unfortunately.
Mhm.
But hopefully you're able to get that taken care of quickly so you can get that airship homestead placed onto the account and get some of that those exemptions placed. But just keep in mind, for the first full year of her passing is going to be removed, and that exemption is not going to, unless you have that airship, then that's going to be removed, and those taxes are due in the full amount within 21 days after it's removed on our end. So
Yeah.
after that, we start collecting
So,
penalty. Yeah, we
yeah.
start
So
collecting
then,
penalty.
so if she passed in January 2024, and I'm in the second year, this is technically I'm within the year that I will technically start to be responsible
Yeah,
because she
so
died in June.
this year would be your first year of being fully
Yeah,
responsible for those taxes. If she passed in January of 24,
yeah.
24 is covered, 25 is not.
Therefore, then the HCAD change of ownership with the death certificate is something I can do now
Yes.
as I work through the. Okay, thank you.
Yes. Mhm.
Well, uh, technically, you're changing it into the estate. You're not changing the owners. You're not changing it into anybody else's name. Let's make sure that you're aware of that. It only
Mhm,
goes into the estate of the deceased person.
mhm,
So it's still in her name. It's not somebody else's.
mhm.
Okay. All right. Only two more questions because I know we are well over our time limit. How can you tell if an estate has been through probate?
You want to call the county clerk's office and ask for the probate department, and they can tell you if there's been a probate set up. You can also, if it's Harris County, Fort Bend County, most counties you can look up online on the county records and see if an estate has been set up. Either, It depends on which is more convenient for you, but it is public record, so they can tell you if someone's opened an estate.
One of the questions that I got right before we started this call, I got a call. Somebody had done the application for probate and so on and so forth. But the property was never switched to the beneficiaries. So the attorney didn't do that part. What's the next step if they've already been through probate? They have letters of testamentary. How does the beneficiary now go through the process of switching?
The attorney should have prepared an executor's deed, which would be
that too.
deeding the house from the executor as the representative of the estate to whoever the beneficiary is. So that's what needs to be done.
Okay. All right. And I hope I answered everybody's questions. I was trying to scroll through and my fingers in this little mouse pad just don't get along too well. So I'm hoping that I did get to everybody's question that was in the chat. If I did not, I do apologize. If it was something that you desperately need to have addressed, then feel free to shoot me an email and I can make sure that it gets to the proper presenter that was on here today to get it answered for you. You all will be receiving a copy of the recording of this presentation along with the chat so that you could see what the responses were in the chat. The contact information for the representatives or the email addresses are in there as well for you all to go back and actually see the documents that were referenced as far as a affidavit of heirship, the transfer on death deed, the automobile transfer, and the link of the recording for the deed scams. And last week's presentation for the wills and estate planning will all be submitted or sent to you all as well for you to go back and watch the recording. We are here the second Thursday of each month for this presentation. So if there were some other kind of questions that you may have next month, feel free to come back. I'm sorry, not next month. July, we are off. We take a break. A much needed breaks. But we will be back in August, the second week in August for the clearing title. The second Thursday in August for the clearing title, and then the first Thursday of the month for the wills and estate planning workshop. So feel free to join us in future times, and we will see sometime in the fall about us presenting Ms. Lisa wills and a trust, a wills versus trust conversation, so we can hurry up and get that out of the way so people can stop asking. Well, they're not gonna stop asking. Let me not say that, but so we can
a more direct answer.
We can put it into more context about one versus the other. We try not to get into the trust conversation because it does get very complicated, and according to specific situations, it's not like a regular will that
yes,
has
no,
to have
maybe.
Yes, no, maybe kind of thing. It's a little bit more complex and a little bit more expensive to actually create. So but we do want to make sure that we do get it addressed. So we will see about planning that in the fall for you all. So
I promise I'll start working on it.
All right, good deal. All right, so thank you all very much. Ms. Donna did a great job today. Really appreciate you filling in for Ms. Mabel. Shay, as always, along with Ms. Lisa, we thank you all very much for taking the time out this afternoon to provide this information to the community. We appreciate you guys wholeheartedly. We appreciate the partnership. We appreciate our participants for actually coming back and joining and watching our presentations and continuing to support A Month of Service. Again, if there are any other presentations that we don't currently offer that you all may be interested in, there is a link that pops up on the screen for a quick survey. If you could fill in that information and kind of let us know how we're doing. If you got the information that you intended to get when you attended this presentation, please let us know how we're doing, and if this information was impactful for you in some way, shape, or form, please let us know. So thank y'all very much. We hope y'all have a wonderful remainder of your afternoon. Stay safe, take care of yourselves, and we will see y'all next time.
Thanks, everybody. Have a great
Bye.
week.
Thank you.
Thank you so much.